Good evening, everybody. It's good to see so many friendly faces here and so many clients, I would say. Um, let, let me start by thanking Candace and the other organizers for inviting me here tonight. I think this is going to be a great opportunity for all of us to learn from each other, to perhaps find some common ground, and to maybe develop some common strategies that we can all use to fight risky landfill proposals all over Ontario. And I see that the title of tonight's event is called Ontario is Going to Waste. I prefer to think of this as Killing Landfills 101. That's what I do, and that's what we hope we achieve in some of the cases that we're doing now across Ontario. Now, as David mentioned, I'm a staff lawyer at CELA. I've been there since 1986, and over those 3 or so decades, I've been very busy fighting landfill fights all over the province of Ontario, Southern Ontario, Central Ontario, Northern Ontario, big or small. We fought them all, public and private, little rinky-dink dumps, big mega landfills, the odd incinerator. And I'm not going to revisit all of that. It's not an opportunity tonight to go through memory lane. I just want to focus on 3 landfill cases, one from each decade, and see if we can draw some lessons learned. The first case that I'd like to mention is the Region of Halton landfill case. This was a case that we did at CELA back in the late 1980s. We represented a group called the West Burlington Citizens Association, and they were concerned about a proposal by the region to put a preferred site at a fractured bedrock location. So needless to say, they were concerned about that. It went to a big public hearing, a lengthy public hearing before the joint board, and a decision was made. I'll get to that in a sec. And then it also spun off into some legal challenges at divisional court. So that's what was on tap in the 1980s. The next case, the second case I'd like to mention is the Adams Mine case, which came up in the 1990s. And again, we were involved in that one. You'll recall that that was a proposal to put Toronto trash on a train, send it up to Northern Ontario, up to Kirkland Lake, and put it in a 600-foot deep open pit mine that was already half full of water. I represented an environmental coalition who didn't think that was such a good idea. So that went off to a hearing before the Environmental Assessment Board. It wasn't a full environmental assessment hearing. It was focused on just one issue, and that was the proposed engineering design to see if it was actually going to protect groundwater or not. Again, I think we spent 4 weeks at that hearing, which was kind of funny. It strikes me as odd that we only spent 15 or 20 hearing days talking about an undertaking whose contaminating lifespan was pretty well close to 1,000 years in length. I mean, that's what the proponent admitted. It was going to be about 900 years before the leachate cleaned itself up. And we got to spend 15 days in Kirkland Lake talking about that. Anyways, the hearing was held, and once again, it spun off into some litigation before the divisional court. And that brings me to my third and final case, and that is the proposed expansion of the Richmond landfill site. That occurred in the early 2000s. And in that case, I represented the Concerned Citizens Committee of Tyendinaga and Environs, and we'll be hearing from my good friend and colleague and client, Mike Bossio, shortly about that case. And as you may know, the Richmond landfill was a big landfill proposal. It was an expansion of an existing site. It was subject to environmental assessment. That environmental assessment process lasted about 7 years, from about 1999 to 2006. We didn't get a hearing in that one, but we got a decision, and yes, litigation was pursued as well. And I'm sharing those cases with you tonight, not to go down memory lane. I'm doing it because they all share 3 common factors, and they have 3 common outcomes. In each of the cases, the preferred or proposed site was located in or on fractured bedrock. And in each case, the ultimate decision was not to allow that proposal to go forward due to groundwater contamination concerns. So after 3 decades of those kinds of fights, I now find myself scratching my head and asking why. You know, why are we still fighting landfills at fractured bedrock sites? Why are proponents allowed to propose landfills at fractured bedrock locations? Why can't Ontario just say no up front to those kinds of sites through prohibitions or clear siting rules that just say no to fractured bedrock sites? Because if we don't have that clear upfront direction built into law, that leaves it open to proponents to continually propose new or expanded landfill sites at fractured bedrock locations and other unsuitable sites. And that, in effect, forces all of you and other concerned residents and citizens groups and local communities to spend a lot of time and a lot of money fighting these sites that really shouldn't be proposed in the first place. So those are kind of the, I would say, the public policy questions that need to be answered, and they can only be answered, or they're best answered, in my view, through legislative reform of the landfill approval process. Now, to kickstart that reform process, earlier this summer, CELA and our friends and allies in the Richmond landfill case, we filed an application for review under the Environmental Bill of Rights, which is another environmental law that we have here in Ontario. And the focus of that EBR application was a request to the Ministry of Environment to review and revise the Environmental Protection Act in a way that prohibits new or expanded landfills at fractured bedrock locations. A fairly common sense proposition, I would suggest to you. And I can report that a lot of people in this room, a lot of people on this panel wrote to the ministry in support of our application. A lot of you wrote excellent emails and letters to the ministry, and we thank you for that support. But as most of you know, about a month ago, the ministry wrote back and said no to the application. Basically, the ministry said, not only are we not going to change the law, we're not even going to review the matter. We're not going to publicly or formally review the need to change the law to protect the environment. And the bottom line, if you've had the chance to read the ministry letter, they seem to think that the existing approvals process works well enough. Well, in my view, and based on my experience, the existing process works well if you're a proponent who wants to construct or build a landfill, especially one at a fractured bedrock location. But the existing process doesn't work so well if you're out to protect the public interest and out to protect the environment against the impacts associated with landfilling at sensitive or vulnerable locations. So I just want to report to you about the ministry's refusal to do anything. I can also assure you that we're not going to take no for an answer. The ministry might be content with the status quo, but we're not. And we certainly intend to pursue this matter very vigorously with the Ministry of the Environment, the Environmental Commissioner of Ontario, the Ontario Legislature, and anybody else we can think of. And I certainly encourage you all to join us in that very important and I think long overdue law reform campaign. But changing the Environmental Protection Act is not the only thing that needs to be done. I think we need to also look at the Environmental Assessment Act itself. The Environmental Assessment Act still does apply to big landfill proposals, and a lot of us in this room are still immersed in these Byzantine EA processes for landfill proposals. But in my view, the environmental assessment process itself needs some major changes to make it more fair and more effective, more protective of the public interest. And so, for example, we need to see an end to these so-called scoped or focused environmental assessments that don't require landfill proponents to actually prove the need for a landfill. You know, as it goes right now, if they get approval to undertake a scoped or focused landfill EA, they don't have to, you know, justify the project at all. And that's wrong. We need to correct that. We also need to see a return to public hearings under the Environmental Assessment Act. It used to be that if there was any significant concern about potential environmental impacts, you got a hearing. You went off to the Independent Environmental Review Tribunal and had a public hearing, and that's the best place, in my view, for these claims by proponents about site safety. Well, you know, that's where you need to prove them. That's where those claims need to be tested and fully scrutinized by this independent decision maker. So we need to have hearings and not have a lot of this stuff decided behind closed doors by political staff. The other thing I'll mention about the environmental assessment process is the need to reestablish the intervenor funding legislation that the Mike Harris Tories allowed to expire in 1996. If we bring back intervenor funding, that'll certainly make it easier for public interest groups to retain the technical and scientific expertise that's needed to fully and meaningfully participate in the EA process. So those are just some of the EA reforms that CELA intends to pursue with the Ontario government. But again, just fixing the EPA, just fixing the Environmental Assessment Act, that's not enough either. We need to look a little further up the pike. And I think if we're going to do anything to fix the landfill siting process or anything to fix the EA process, we also need to make some changes to ensure some substantial provincial progress in waste reduction, reuse, and recycling. And that's simply because if we can make a real dent in the overall waste stream, if we can minimize the amount of residual waste that might require disposal, then hopefully we would see a corresponding decrease in the number and size and capacity of these mega landfills that proponents keep trying to shove down our throats. So on that point, I would encourage all of you to take a look at Bill 91, which is currently in front of the Ontario Legislature. That's the bill that's entitled Waste Reduction Act. It's the Ontario government's latest attempt to expedite or improve the 3 Rs in this province. If you want more detail about it, you can go to our website, cela.ca. We've written about this brief. We've identified some things that need to be changed or improved. And at some point, probably in the new year, that bill will go to a legislative committee for public hearings. And at that stage, I would encourage everybody in this room to make written submissions to the committee or even request to appear as a witness at these committees. Mostly because I think the MPPs on the committee will need to hear directly from people who are concerned about what happens when you don't get serious about 3 Rs, when you let that dawdle or stall, and that leaves the door open for proponents to come forward with these mega landfills at unsuitable sites. So the MPPs need to hear that forcefully from the communities and from individuals who are most impacted by that kind of an approach. So just to let me wrap up, the bottom line is we really do need to get serious on the 3 Rs. We need to get really serious with the 3 Rs in the industrial and commercial and institutional sector. There's lots of room for improvement there. So I didn't even bring my watch, but I'm sure I'm out of time. So I'm just going to stop right there. I think we can anticipate we'll have a good and fulsome discussion about some of these issues when we have our panel discussion. So with that, let me turn it back over to David.